Good morning. The sentencing for Dr. Conrad Murray just concluded. Although it was a lengthy sentencing, we can draw some lessons from what transpired there. First of all, the public, through this widely televised and viewed trial, especially here in the United States of America, don't have a sense that prescribed drug overdose deaths are a threat to them in general, then they've missed the point. The number one cause of unnatural deaths in the United States of America this year was prescription drug overdoses, surpassing fatal traffic accidents. Some of the people who are complicit in that scourge that is killing people like Michael Jackson and thousands of others are people like Dr. Conrad Murray, the so-called Dr. Feelgood doctors who, because of their greed and selfishness, abandon their ethics and put other people in harm's way. So that's a lesson to be drawn from today. Another lesson, a much smaller lesson, but a lesson to be drawn from today, is the fact that AB 109, California's so-called prison realignment, is presenting problems in what should be rather routine cases. Clearly today, the judge thoughtfully struggled with whether or not the sentence that we describe as a state prison sentence can actually be served in state prison. And I think that illustrates the falsity and the falseness of AB 109. The court ruled that, according to his interpretation, Dr. Conrad Murray will serve his state prison sentence in the county jail. This may be an appropriate issue for appeal. Although we respect and admire the judge's findings today, we think that this issue is presented by AB 109, the state's realignment law, which was rushed into law without much thought by our state legislature and signed by our governor without much thought of the unintended and intended consequences. It's a fool's errand. It's a bad law. It's public safety endangering, and I think that this is going to be the first of many high publicity cases where the public is going to realize they were let down by their state government, who are not willing to fulfill a basic core mission of public protection and public safety after someone's been duly found guilty and sentenced to state prison by a judge according to law. Now, the last time we were here, Dave Walger and Deborah Brazil were very brief in their comments out of respect for the court and the fact that sentencing was pending. They can be more expansive today. I commend both of them for their work. Their presentation was superb. Their professionalism is obvious, and I'm very, very proud to be Los Angeles County's district attorney when I have employees like this, colleagues like this, doing such a great job and showing what this office is made of. With that, Dave, Deborah.
Morning.
Have there been any discussions with Sheriff Lee Baca about what this term will actually mean in terms of what Conrad Murray actually serves in county jail?
Not by myself. I don't know if you want to direct that to someone else, but no.
You don't know whether this could be...
We've not specifically talked about this case. We anxiously await to see how these sentences will be imposed under realignment and the sheriff's broad powers to sentence under his current authority. We anticipate if Sheriff Baca is consistent with what is happening in the first several hundred cases that are going to him as non-nons in a realignment, that Dr. Murray's sentence in terms of true incarceration might be very short. Many cases that we now know about have been sentenced to state prison under the non theory and then committed to the Los Angeles County jail custody are being released early. We know that for a fact. We'll see if that fact plays out in this particular high-profile case.
Well, for clarity, Mr. District Attorney, so a 4-year jail sentence, you know realignment and you understand prison crowding, and you talk to the sheriff. What do you think this sentence will eventually be, and what's your reaction?
Actually, I don't know what the sentence will actually be, and I can't predict because no one whom I know no law enforcement professional really has a handle on the sheriff's early release policies. The question is the sheriff going to take his historic, long-standing early release policies, which in the Lindsay Lohan case meant 5 hours against 30 days, in another case that we handled where a woman went out and killed 3 people, she got a 90-day sentence, was out in 2. We just don't know. This is one of the great mysteries of life, is what amount of time someone is going to actually do when they're sentenced to it by a judge. We're somewhat clueless on this topic, which is one of the great failings of the Rutherford decision, where the sheriff was given power to early release individuals, and AB 109, which extended that power to people otherwise sentenced to state prison.
So you lobbied the judge for this sentence. Do you now need to lobby the sheriff?
Well, unfortunately, the sheriff, because of AB 109 and because of the Rutherford decision, the federal consent decree, now plays a bigger role in sentencing than judges do. And that's an unfortunate misuse of executive power. A judge's order, according to law, should be honored and respected. And right now, I don't think it is. But the sheriff is operating, perhaps lawfully, under this realignment plan and under his historic powers. This is going to be a real test of our criminal justice system to see if it's meaningful at all. And I think watch this case and listen to us as we speak about other cases when people are sentenced to state prison and never go there, go to county jail, and are released early.
Mr. President, were you saying that you were going to take an independent appeal on this question?
We think we have jurisdiction to appeal. The Court of Appeal has jurisdiction to look at the narrow issue of the conflict of laws as to whether or not an involuntary manslaughter under a certain penal code section amounts to a serious felony. That would take it out of the non-category. Of course, within 120 days, Judge Pastor can revisit that issue on his own, and we may have more opportunity to provide him with more extensive points and authorities that we think would support the conclusion that this is outside of realignment and could be, and the term could be spent in the state prison system.
What happens in 120 days?
Within 120 days, the court can recall his sentence and modify it at his discretion. After the 120 days, the court loses jurisdiction. We intend to file, if we conclude that we are correct, that this is a serious felony, we intend to file the appropriate paperwork for the court to reconsider this sentence and maybe do what the court would like to do, which is sentence Dr. Murray to real state prison.
I've been talking to some of the fans down the hallway, and a lot of people have these feelings that the case should have been second-degree murder. Can you?
Yeah, I got about 10,000 emails to that effect.
What is your comment on that?
We filed the most accurate and appropriate charge. We did consider implied malice as a theory for second-degree murder, and after a careful consideration of the jury instructions and the facts that were available to us, we concluded involuntary manslaughter was the appropriate charge and represented the gravamen of this particular offense. I know the fans feel strongly about their icon, their hero, and that's fine. That's not how we make decisions here.
Mr. Cooley, if I could just ask you, will the sheriff does he have complete control over one person versus another? In other words, if we had another case that was identical but didn't involve Michael Jackson, I guess what I'm asking...
Or didn't involve Conrad Murray.
Right, doesn't involve Conrad Murray, Michael Jackson case. Could he elect in one case to do one thing and another case do another thing as far as releasing somebody? Because he's going to have a lot of manpower involved, and he's going to have to be segregated from other prisoners. It's going to be more expensive. Are you concerned about that? I'm
very concerned about that. I've been concerned about that not just in the context of this case, but in the context of the long-standing early release program employed by the sheriff that makes a mockery out of sentences duly imposed by the court and is somewhat arbitrary and capricious, and does provide a mechanism that, based upon bed space or bed space constraints, similarly situated people are being sentenced differently. And that is not the way we should run a justice system. And I think that hopefully this case and other cases under on will provide many examples so that there should be corrective action in the federal court that's had jurisdiction over the county jail since 1978 and elsewhere. The jail commission, the supervisors have appointed, and the public at large can learn more about how early release is colliding with jail capacity and other issues, and it'll be aggravated by non type cases under AB 109, which means people that a judge says you're sentenced to state prison is not really going to be doing much time. That's the bottom line. Pardon me? Well, there are lots of different solutions to the Plotter decision, the Supreme Court decision that suggested the overcrowding in California state prisons was cruel and unusual. I've listed those before other audiences, but there were a number of different solutions that could have been employed. AB 109 was not a solution. AB 109 was an abandonment of the state's historic responsibilities when it comes to keeping people in custody who are a threat to the law-abiding public. And the governor and the state legislature and those people that embraced this concept or were architects of it have created a scenario that's going to threaten public safety in the future that's easily predictable.
If Conrad Murray gets out early, or when he gets out early, what's his life? Does he have an ankle bracelet? Is he on probation? Can he go wherever?
It depends what the sheriff agrees to. He could report to a day center, sign in. He could have an ankle bracelet, and there's various models of that. Kmart, up to Macy's, and the sheriff could select that. There's a wide variety of sentences that don't involve custody for which Dr. Murray would receive full custody credits against his so-called state prison sentence.
Do you have any influence over that stage of things?
No, it's generally within the powers of the sheriff.
Well, were you surprised at all that the audio tapes and the documentary had such an impact on the judge's sentencing today? He even went into detail about how much he felt that Murray's character came into play. He spent a lot of time referencing it. Was that what you anticipated?
I was not surprised by it. In our sentencing memorandum, we had included the fact of the documentary and some of the statements that Conrad Murray had made that he chose to make in that documentary, including the one we had cited in our memo, that he did not feel guilty because he did not do anything wrong. We'd also cited his statements that he felt that he had been betrayed by the victim and had been entrapped by the victim. In regard to the audio recording, I think the questions posed by the judge are questions everyone's been asking. What legitimate purpose would Conrad Murray have had to make that recording? So I think that was a powerful piece of evidence during the trial, and obviously the judge thought it was a powerful piece of evidence as it related to Conrad Murray's character.
What were your thoughts when you viewed the documentary? What were you thinking? Were you surprised by anything in it?
I didn't see the entire documentary. The portions I saw, I can't really say I was surprised by sections of it as opposed to others. I was a little bit surprised that it was made.
Dr. Murray never took a stand. If you had a chance to question him, is there any one question you really wanted to ask?
There would have been a lot of questions. There would have been a lot of questions. It wouldn't have been just one question. There were so many things that were done improperly, so many violations of the standard of care, that it would have been very lengthy.
The judge appeared to suggest that Murray was planning to blackmail Michael Jackson with this audio recording. Did you agree with that?
I think it's a very plausible explanation. Again, when you look at it and you try to determine, okay, what legitimate purpose was there, I don't know what other answer you come up with. It was on his phone. You hear his voice in the background while he's making the recording, and he then retained it on his phone for some period of time, and was still on his phone, obviously, when recovered by the police. So that certainly begs the question, what legitimate purpose was there, other than some type of insurance policy, as Judge Pastor referenced.
Mr. Williams, the judge imposed the maximum 4-year sentence, even though it might not be certified state prison. How do you react to the fact that you did succeeded in getting the 4-year maximum sentence?
Well, we're pleased. That's what we thought was appropriate. The judge obviously agreed with us. And again, as I had highlighted in court today, it was our position that it was not just a simple one-time mistake or error of judgment. It was a series of mistakes and extreme violations of the standard of care, culminating in the abandonment of Michael Jackson when he died. The judge agreed with that assessment and imposed the maximum sentence, which obviously we had advocated, and agreed with the court's decision and his reasoning, which I thought was very powerful and persuasive. And obviously he was very much attentive to the trial and very much attentive to the evidence that had been presented over the 6 weeks.
Are you concerned with a lot of work with little payoff if indeed the sentence is not 4 years but turns out to be less than half that, maybe 1 year, maybe even less?
No, the payoff is again, a brother and a son and a family member was killed. And whatever the sentence may be, that family of whomever that victim may be deserves justice. And we did everything we could to bring that justice within the bounds of the law that exists. That's what we did. We think we did it well, and we got the sentence that we asked for.
Speaking of family, can you talk about the process that led to the statement that was read on behalf of the family today, and more broadly just about your relations, your interactions with the family for the past couple of years?
I'm not going to comment on any specific conversations, but my relations with the family have been very productive. I've been very impressed by the family, very impressed by their resilience and what I've learned from them about Michael Jackson personally, and they've been nothing but very respectful and supportive of not only the process but our efforts in the process.
David, this sentence is relatively short, so are you concerned he'll get out and just go to maybe another state and practice medicine there? Is there a possibility?
Again, we were presented with the facts and the evidence in this case within the bounds of the law that exists, and we put forth the facts and the evidence and got the sentence that we requested. As far as what Conrad Murray may do after serving his sentence remains to be seen.
But, are you concerned that you could be out there in a year and Houston maybe doing this?
It is a concern that he would be practicing medicine with. Yes, that is a concern.
Did you speak to the family after the ruling today? What was their reaction?
They just mouthed the words, "Thank you."
Ms. Brazil, could we talk to you real quick? Your experience as a prosecutor, when a defendant acknowledges some fault or some remorse during the course of the trial, what impact does that have, or potentially, on a judge or a jury?
I think remorse is an important component to show that a person accepts responsibility for their criminal conduct. However, the goals and aims of sentencing do not contemplate fully remorse. Rather, it's important that society has a measure of punishment, and rehabilitation must also occur. So while remorse is important, it would not be, in my view, a significant factor in terms of appropriate sentencing.
But the judge brought it up frequently, did he not?
Yes, he did, and he also weighed the lack of remorse exhibited by Conrad Murray, which would be the appropriate procedure, in my view.
Was there a turning point in this case at all for you? At some point you realized that you had the jury?
No. We approached this case from the very beginning, marshaling the evidence. Mr. Walgren was the architect of the prosecution in this matter and did an astounding job. We presented the evidence every day and trusted that the jury would evaluate the evidence as we saw, and accordingly, they convicted him.
Can I ask both of you, was this the most difficult case you've ever done?
No.
No.
Can you say what was?
No. I'd have to think about that.
No.
Can you guys talk about what it was like to walk down the halls and just get applauded and have people blowing you kisses? It's not the normal.
Well, really, it's pretty normal.
It was definitely unique. Not something you imagine as a lawyer that you walk out of court and experience. But other than that, it seemed sincere and better than the alternative.
Mr. Morgan, I'm sure we can expect in several states administrative proceedings by medical boards against Conrad Murray. The start of investigations. Will the district attorney's office be weighing in and offering testimony and evidence in those administrative proceedings against Dr. Murray?
I'm not an expert in...
I think that the conviction itself will serve as the basis for the collateral consequence of his license being suspended wherever it's active. We will provide documentation of that conviction to assure that to the extent possible all other states can exercise their prerogatives to suspend it and then terminate his license.
But does he have the opportunity to go to another state that he hasn't ever applied to?
He may want to go and apply, and we'll be following him with our certified copy of his felony conviction for involuntary manslaughter of one of his patients. And they want further documentation. We'll pay for the transcripts from the trial.
He could go to another country then?
He could go to another country. We don't have any jurisdiction over other countries. But if they want our cooperation, we'll gladly provide it. Thank you all very much.
Thank you.
Thank you.